Welcome, everyone. We're thrilled you were able to attend today. I'm also joined by my partners, Chaz Billington and Laura Geyer. Chaz works in the area of labor and human resources law, helping companies with issues there. And Laura works in the area of trademark and copyright protection and clearance. And we're thrilled to have all of you with us. Let me go ahead and get the slide deck to where you can see our slides, and then we'll talk to them. And our goal is to make this interactive. So please, if you have some questions, you're using these tools, if you have any questions about the content we're talking about, feel free to put them in the Q&A, and we'll address them as we go and at the end. So what we want to cover today is we want to talk about what the buzz is about. We want to give you a sense of the power of these tools. And we really want to be practical in that we want to look at some example use cases in companies that we know about, that we've thought about, as well as the limits and the rights and responsibilities. We're primarily going to focus on an employment context when employees are using these tools in your organization. And we're also going to look at the intellectual property aspects, which are considerable. And we're primarily going to focus on some of the trademark, copyright, and other aspects of intellectual property that come into play. We want to look at the terms of use and content policies to give you a preview of those. And then we also want to close with some guidelines, some do's and don'ts, and things that you might be able to take away with you. So what's all the buzz about? To give you a flavor of these tools, the new aspect in our minds, why it's getting so much attention, especially in the last 30 days or so, is these are very powerful tools for creating new content. And the main areas and tools we'll look at are the ones that are creating content for new images, new drawings, some of them like DALL-E, Midjourney, you may have heard about. These are powerful ways in which companies and organizations can create new images. Just to give you an example, here's one that I created this past weekend. The way it works, and for example, many of these tools like DALL-E 2, you just type in a description, cubist style of a printed circuit board in CAT, for example. And this is one of the output images that DALL-E 2 created. But they're not just limited to drawing and images. Some of the tools generate conversational chat, and they're very powerful generational chat that have real kinds of conversations. So one of the examples, for example, I have right here on the slide is from ChatGPT 3.5, which is one of the leading ones that OpenAI is made available to the public. If you just type in, right, Super Bowl commercial with a printed circuit board and a cat, within about 15 seconds, you get this kind of output from the tool. And you can see it sort of, I won't go through the whole description, but it basically writes a Super Bowl commercial. It sets a scene with a cat on a table, looking at a printed circuit board with curiosity. The circuit board has some components. There's a voiceover saying, hey, here's the latest innovation in cat entertainment, the cat toy, Circuit Cat toy. And then it even gives some description of sort of how the commercial would play out with the cat sort of batting about some of the components. And then the voiceover basically saying, you know, your cat's never going to be bored again. Use this. And in some ways, I think this captures what is striking about these tools now, in that within 15 seconds, you get some generated content entirely new based on training data that you can actually use in a multiple of ways. And it's not limited to this Super Bowl commercial. There's, you know, we're seeing examples of people saying, hey, write a radio skit, write a news bulletin, write a screenplay. There's a number of things that you can ask the tool to generate content for you, not just chat. There's also an aspect to these tools that generate actual code, primarily Python, HTML, some of the stuff that's used in web pages and web programming, and it's expanding to other programming languages too. I just gave you an example here that you can use in OpenAI's Codex tool. And that's a tool, if you just type in the description, as I did, create a web page with the title Printed Circuit Board in CAT, and then I just sort of pasted below the output that you get. And again, it's kind of Google search speed. You get it in about 15 seconds. You get this sort of, text, HTML text for creating a printed circuit board in CAT. When you go back to thinking about what the buzz is about, the way I think about it is, a skeptic might look at all this and say, "Hey, we've had these kind of tools around, for decades now. What is new about this? We've had search. Some of you, like me, remember Alta Vista and Yahoo, some of those directory-based searches we used to have. Then we had Google and other systems that used PageRank and some other ways of linking data. And we've also had chatbots. Many of you probably interacted with Siri or Alexa. If you travel the Northeast Corridor on trains, some companies like Amtrak will have a virtual assistant chatbot that'll answer your questions. We've had that out there. So what is new now? And especially, how does it impact in-house counsel and others that are thinking of using the latest generation tools in their companies? And that's what we're looking at. These new generative AI tools operate on a very different principle. So if you think about search engines and those type of systems, they have a corpus of documents, there's some indexing, there's a lot of processing of the data, but primarily for a search result, you have a request for a search term and you're getting a result. And looking at the result, and many of us are familiar with that in our organizations, how you manage search result hits and the content that comes from. And kind of the same way with chatbots, you're kind of used to asking limited queries within a particular domain and getting very limited answers. With respect to generative AI tools that we're looking at today, your employees, yourselves, whoever's using it in your company, are getting entirely different types of content back. I mentioned you can get a Super Bowl commercial or radio or exam answers. There's a lot of different types of content, and it's new content, but it's not entirely new, as we'll get into. It's basically based on a principle of a machine learning engine. So when you look underneath the hood, there's training data that is being used to train the machine learning engine, and then that model is being used to operate on the input. And when you type in your description saying, "Hey, I want a Super Bowl commercial with a printed circuit board and a cat," it generates the output based on the enormous training that it's already done. And that's when it's operating in inference mode to kind of give you the output that you want. And those types of new content, that is not, the content moderation is very different. And this is one of the things we want to emphasize in this webinar. Your in-house counsel looking at risks and assessing usage. We're getting a little better at content moderation with respect to the older tools like search. And so there, to improve content moderation, it was like, well, make sure I trust the source. This came from the New York Times. I have access to that. I can use that image. This came from another source that I'm familiar with. We can use that image. We have some content moderation that we're used to. When it's coming out of a machine learning engine or an AI chat tool, it's being created based on this training data and other types of data, and it's giving you new content that makes it more difficult for employees and managers to assess the appropriateness, the permissions, and the rights and responsibilities with that new content. And so let's just look at ChatGPT 3.5. That's kind of one of the tool that's had the explosive growth in the last 2 months, going from 1 million monthly users to 100 million users within 2 months. One AI consultant estimates that ChatGPT is outputting every day now 110 times the volume of tweets on Twitter, the equivalent volume of printed works in human history every 14 days. So even though it's only been out 2 months in its current form, the usage and growth has been dramatic and exponential. Lawyers got, caught their attention when ChatGPT 3.5 passed 2 sections of the multi-state bar exam, in particular evidence and torts. When you fed in questions from a sample exam, passed those 2 sections. So the intelligence and the content are real and the volume is large. We won't go into too much under the hood, but when you look at the neural network architecture, it's a very robust neural network architecture. It's attention-based. which is kind of a common approach now, getting more common, that uses attention to sort of where to direct the machine learning model. But these involve millions and millions of calculations and multiple layers to take the input data to reach to an output data. And in terms of orders of magnitude improvement over the prior version of ChatGPT, the current version was trained with 175 billion parameters, which is just far multiple orders of magnitude different than what we've seen before. And it's busy and popular. And even when it's busy and popular, the messages are quite creative. Here's one that I got a couple of weeks ago, where trying to use ChatGPT, and it gave me the answer, system busy, in the language of a pirate. So the creative content continues. And so now we'll turn it over to Chaz. We want to make sure, we want to look at some of the very specific use cases that you're likely to encounter in a company and look at it from an HR perspective. And then Laura will pick up on the intellectual property perspective.
All right, thanks, Mike. So, as I've been talking about, and the reason why you're here is AI is so hot right now, right? It is the proverbial hot baked potato. Everybody's talking about it and talking about it a couple different ways, right? In the workplace particularly, it's either the latest, greatest tech unicorn that's coming for all of our jobs, or it's one thing that's going to save all of our jobs. And now we're all dialed into it because, particularly for folks in this webinar, it's going to replace the lawyers. So now we're all very keenly interested in it. What we're seeing, at least the trends I'm seeing, is more AI augmentation of the workplace rather than supplementation, right? We're not seeing people being replaced by AI. We're seeing them use it, and companies use it to augment the existing workforce. And the interesting thing is, and some of the examples I'll give today, is that AI, whether you know it or not, is probably at use in some way in your workplace right now. And I'll give you some concrete examples of what we've seen and what we're seeing, and then I'll engage in some absolutely rank speculation at the end as to how it could be used and how you could find yourself in some trouble with it. So we'll talk about some fun examples as we go through this. And the goal for my section particularly here is just get you thinking about it, get you issue spotting. It's not going away anymore. You can't ignore this. It is a growing trend. And certainly, ignoring it could bring some risk to the organization, and wouldn't be a lawyer webinar if I didn't have that little disclaimer about the world is coming to an end and this is scary stuff here. But certainly you should be educated. You should be able to issue spot it and start to implement some of the best practices and things that we will talk about through the presentation. And I am switching slides here. Give me a second, everybody. There we go. So how are companies using AI? A variety of different ways. You may be doing them yourself, right? So chat box for engagement and routine HR requests. You might have a shared services center that looks a lot like a person, but is in fact an is an AI representative answering questions. It's fairly interesting that some of the chat softwares I've seen, it can actually go through, look at your handbook, look at FAQs and things like that, and are pretty doggone convincing in answering questions to the employee base. It's used a lot in talent attraction as well. AI-driven recruiting tools, rather, whether that's the actual AI doing the selection, or it is matching, or even chatting with folks who are applying to the organization. You see it a lot in performance management, right? Whether that's actually performance managing employees through the organization, but restructuring. I've seen it in the layoff context, analyzing the organization for efficiency and the future workforce. Seeing it in career development. At the end of the day, one thing I want to highlight here is that it's certainly not perfect. And we know that not because we've seen it battle tested. And that's one of the biggest issues we're seeing, is that it's not widespread enough that we've seen litigation. We've seen, a lot of guidance and things like that. And we'll talk a little bit about the guidance that's out there, but certainly this has not been heavily litigated. We're not sure exactly what the legal landscape is going to look like for the purely employee side of things. And so I'm going to call out some of that stuff here as well. So how do employees use it? We know employers use it. We know that they use it a lot, actually, but how do employees use it? They use it for a variety of different ways, and I won't belabor the point to go through all of these, but this is the way ChatGPT is being used in the workplace. You have some of the more recent examples are what Mike provided, right? Dumping code into it and having it develop code, but you're seeing it in marketing as well. People generating marketing content, whether that's pictures, the blurbs, LinkedIn posts. I can tell you I've generated, just messing around with it, a number of LinkedIn posts. I would argue you could generate probably a blog and an email announcing that blog and a LinkedIn post to go along with that blog based on a ChatGPT interface. And the biggest issues we see here are that, we don't know what the input is that's getting us the output. You don't know if it's faulty information. We don't know where it's coming from. But as you can see in some of my examples, it is extremely convincing. How do I know that it's really convincing? I will tell you how I know that it's really convincing. Plot twist. So that last slide was generated, in fact, by ChatGPT. Looks wildly convincing. Looks like a lawyer wrote it. I guess maybe that means we write like robots or robots write like us. I'm not sure. But certainly I would argue that that last slide looked a lot like something that was generated from anybody inside of an organization, right? Whether that's a comms person, a marketing person, or a lawyer. Tough to tell. And, it really highlights the point that this stuff is really handy. It actually does work to some degree, and it should also raise the skepticism about the output of and make you more discerning in the way that you use it and the human actual intervention at some point. But the point here is at the end of the day, it works, right? So let's talk about it in the workplace, very high level, no federal laws yet, but a couple of things you as employers, if you're in-house counsel, you're outside, if you're an HR consultant, you should be thinking about is a couple of things. One, the EEOC issued guidance. It's linked there. Some of the materials we'll send out will include the link there. But the EEOC last year issued guidance on the use of AI and how it could theoretically discriminate against individuals with disabilities. Gave a couple of concrete examples. Look, failure to recognize that somebody might need an accommodation because it's a bot and it doesn't get that. And that could be a form of discrimination. Screening out applicants because they have a gap in employment, but that gap may be because of some kind of medical issue or something like that, or screening out individuals based on analysis of a video content of speech patterns and things like that. And again, that could be something that's related to a disability. EEOC's out in front of that, really highlighting it. White House's AI or blueprint for an AI Bill of Rights, also really interesting. One of the big focuses on it is this concept, and it's a term we're going to hear more and more, algorithmic discrimination. Sounds extremely fancy and interesting, and it really kind of is. And it is the heart of what we're talking about when we talk on this slide about the watch-outs for the use of AI as the organization. It is that the system itself using algorithms to do whatever it's doing, some of the examples I talked about earlier, actually the output is discrimination because the system is not looking for that. It's not recognizing that. I'd encourage you to go read that because I think a lot of the laws that we're going to see get passed, and we'll talk about some state laws in a second here, are sort of based on some of these primary concept. Notice, right? Providing notice to applicants and employees and consumers that you are using an AI and how it works and what you're doing with their data. Likewise, and as you jump in here, you can see Illinois got a law. So does Maryland, very similar laws. Both of them basically just say you got to notify applicants if you are using AI to analyze a video from an interview. You got to consider how that information is being shared. There are certain notice provisions. Both those laws look at that. New York City's is similar. Basically says that if you're using automated employment decision-making tools to screen candidates within New York City, you have to do what's called a bias audit. And there are certain notice requirements as well. So these things are on the forefront. They are bleeding edge, sure, but states are even starting now to catch on. There's other pending legislation. And one of the examples I'll give you here into why this sort of came to the forefront a couple of years ago, Amazon built this system that was an automated system for recruitment. They ultimately shut the system down because when it was predicting the best candidates for a job, it found out that it had a disparate impact on women. It wasn't choosing women as frequently as men. And the reason why, it was based on the way the system was built, the input. It based its criterias like usage of words like executed or captured, which were mostly found in male resumes rather than female resumes, as a way to screen or better match people in the job. So in 2017, they ultimately killed that system. Don't know if it came back in some other form, but again, it's not necessarily something they intentionally did. It's just the output, the potential issue with the use of these kinds of software in the workplace. So let's give you quick examples of what can happen in real life. Employees, this is again another one that both Amazon and Microsoft have talked about, employees loading confidential proprietary information into these systems like a chat GPT because they are either summarizing or idea generating. They are creating content based off of other content. These are very real data protection and privacy concerns as well. Likewise, if you are using a recruiting software, performance management software that has employee data loaded into it, where's that data going? What's happening with it? What are the rules and regulations relative to what your vendor can do with that information once it has it? All of these are huge concerns and warrant looking at the contracts you're entering into and the usage of usage of AI in the workplace. It's great. I have another example here, which is something somebody posted on an online portal. I've been using Chat GPT to summarize company decks, right? Slide decks, and essentially distill them down. And so this is a great example of what you could do with it, right? You could imagine a reality where you're getting ready for some kind of big meeting and you got a bunch of proprietary information and maybe marketing information and trade secrets and all kind of stuff. You load it into Chat GPT and you say, make me a slide deck based on all this stuff. Well, that information now is out there. And we'll talk about some of the terms of service, and Mike touched on that a little bit as well. That information now lives out there somewhere where you don't control it. And the example here is that Amazon had started to audit Chat GPT and found that some of its internal data was popping up in the Chat GPT interface because it had been loaded in theoretically or most likely by some employee at some point. And they were able to point directly to, yeah, no, that's proprietary information. That shouldn't be in there. Microsoft, same thing. They both got out and started to essentially counsel and warn employees about, what are the rules with the rules of the road here with respect to what you can and can't put into a public workspace, and educating people more fully about what exactly is happening to the data once it's put out there. Next up, this is an interesting one as well, and I'll give you some examples quickly, but it's really easy to create a contract. It's really easy to create a policy in Chat GPT. Email me if you want. I got a bunch of examples, but do it yourself. Go on to Chat GPT. Hey, make me a sexual harassment policy. Hey, make me a release of liability. Make me a separation agreement. It's extremely easy, and I got to tell you, the output looks pretty good. And so here's an example of one that I put together as part of this presentation. I said, hey, draft me an at-will disclaimer for an employee handbook. Bam, there it is. Looks pretty convincing. Might match exactly what you've done in your workplace. I would argue it's largely right. The issue is it may not necessarily comply, particularly with state law, right? South Carolina's got this law about, underlining and capitalizing the at-will disclaimer. Well, this wouldn't do that, right? There are idiosyncratic issues with state law and other things to consider where, yeah, this looks great at first blush, right? This absolutely looks awesome. Like, you could use this. And it's very enticing to that end for employees to say, well, why do I need legal to go draft some contract and wait for, red line revisions or whatever, when I could just go out and have this computer do it for me? And I got to tell you, it looks just like what a lawyer did. Here's another example. It's a release of claims agreement. This is just a section of it. But I can tell you, it's missing some very specific things that I, as a lawyer, would want in your agreement. But again, at first blush, it looks really good. It looks like the real deal. That this person's over 40, you're going to be missing the OWBPA waiver. Likewise, there are some information in there about waiving potential rights and claims that can't be released and things like that that aren't necessarily going to comply. And then there are state level regulations as well that you need to be aware of. And so again, the danger here is that employees can just turn to this as a really quick means to generate the content that they think looks great, looks normal, right? And it warrants getting out ahead of that and understanding how your people are using it and warning them that, this is not a, some kind of miracle cure for not having to go to the legal department. Let's talk a little bit about some other things we've seen. Generating content, right? And Laura will cover this in way more detail. I just want to tell you, so I did this. I was curious. I'm like, oh, what's a picture of me talking to a group of people, right? So I put in, my specifics. I talked about, what I look like. I have a blue suit, and I'm talking to a group of people, and it's a lawyer who's got some facial hair. And the output I got was this. Bears a striking resemblance to someone, and that person, I would argue, is not me, although it's flattering, quite frankly, for the AI generating tool that generated this image. This image looks a whole lot like Ryan Reynolds. If that were to get out in the open, maybe that's appropriation of a name or likeness. I'm not entirely sure. Again, leave that to Laura. That's her neck of the woods. But understand that this is the kind of power this stuff has, that it can easily create content that your employees are going to find incredibly easy to do, and really, and the danger and the desire to do it is absolutely there. Again, I've screwed around with it, and I got to tell you, it is handy. It's very, very interesting. So last but not least, I promised you, and I will follow through on that promise, some absolute rank speculation about what could happen going forward. And so here's a couple things. One, could a chatbot harass an employee? I don't know, but the example here I would give is that Microsoft had a chatbot that Twitter taught over the course of like 6 months to to come out with tweets that were in praise of Hitler. It learned that from the internet, 2023, folks. The bias is how the stuff is learning, where it's learning from is critically important. And so could a chatbot that you're using, where maybe you don't own the code, you don't know where it's coming from, harass an employee, you could be liable? Yeah, I think that's a real possibility. Likewise, what if you're using a chatbot to intake or talk to employees relative to HR concerns? Well, what if somebody says something that it doesn't necessarily pick up as a harassment complaint? Could you be liable? Well, you certainly could hurt you from a defense perspective. You need to take a prompt remedial action to harassment. And if you miss that, that's going to hurt you there. And likewise, what if somebody uses some kind of slang? It says to the chatbot, hey, I got to take leave, or I'm going to be out a week because I got the Rona. Does that understand that that is a request for FMLA leave? It very well may not, right? And could leave you liable for potential issues. And as we go through the discrimination angle, I would again point you to that EEOC guidance. That's where the real risk is there, is these things having biases built into them that you are not aware of, that the output of that bias is potentially a claim for either disparate impact or disparate treatment, particularly when you're talking about recruiting and you're talking about using it for performance management. So again, as we round out, this stuff's there. It is handy enough that your employees are at least looking at it. You as a company may also be using AI, and we'll talk best practices later, but, understanding what you got, how you're using it, and articulating clearly the rules of the road, those things are all critically important. And with that, I will turn it over to Laura for her part of the presentation.
Okay. Hi, folks. All right, I'm going to flip forward to my thing. Now, just picking up on something that Chaz said, lawyers, of course, are just disaster predictors. It's why we're no fun at parties and people don't ask us questions that are difficult. They know that we'll just tell them what terrible, terrible things will happen. So the moment that the AI started being used regularly to generate content, and especially in the last few months when it got so clever, instantly we all started thinking about, okay, so where does the content come from? Like, anytime you have content being generated, you've got potential issues. So you've got copyright for original works that may not belong to you. You have a trademark for unauthorized use of other people's marks, and also you can damage your own brand by doing things that, for example, create biased content. Your own company's trade secrets could end up taking a walk outside. And a lot of times when you're infringing, you're doing a lot of these things at the same time. So with that, I'm going to get into a little bit more detail. So for copyright, you've got a situation where somebody else owns works of original authorship that are just out there. They could be in any fixed medium, and that includes the internet. And maybe the best way to think of the internet from a copyright perspective is like a gigantic bookstore. So you wouldn't wander into a bookstore and just start taking pictures of pages from books or sections from books and posting them. Well, I hope you wouldn't. But people don't think that when they're doing this from the internet, that's exactly what they're doing or possibly doing. So whose is it? Where is it coming from? Is it original? Is it available to use? Is it available only under certain kinds of Creative Commons licenses where, sure, it's free to use, but it's not free to use without some sort of proper credit under whatever kind of license it's available under? And all of those licenses are different. So even if you're yanking from, say, Wikimedia Commons, you still have to be careful about what you say about it and how you use it. And you have to educate your employees who are responsible for outward-facing content, or those who monitor third-party content that's hosted by your company. So anytime a cease and desist letter comes over our transom, or an employee asks for permission to do something, or we get a call from general counsel saying, Moan, this terrible thing happened, one of the things that I hear first is, it came from the internet. And that happens so often that I've come to think of it like a monster movie or horror movie statement. So they'll say, but I credited it. Well, if it's original to somebody else and they haven't given you permission to use it, proper credit doesn't do anything, doesn't give you permission to reproduce. But it didn't have a notice, that doesn't matter. It doesn't matter if you can't tell where it came from. If it's original to somebody else, that's copyright infringing. Taking it down right away doesn't spare you. It helps, but you're still liable for the copyright infringement that took place during the time that that stuff was online. And it's really expensive mistake to make. Copyright infringement carries enormous possible liability, including statutory damages in certain cases. So it came from the internet is something I hate to hear, and I hope you guys will hate to hear it too. And the reason for this is everyone needs to get ready for Getty. So as some of you may know, images can be created, these AIs will use images pulled from other sources to generate images. And so Stability AI is one of the big content scoopers. And it's no different than a lot of the others, but it uses, it was inevitable that a giant that would create image output using images is going to come up against another giant who provides that content and not in a permitted way. So all you have to do is read the first paragraph of this complaint that was filed just a couple months ago to understand how exciting this is all going to be from a liability perspective. So it just starts. This case arises from Stability AI's brazen infringement of Getty's images, intellectual property on a staggering scale. Staggering. Upon information and belief, Stability AI has copied more than 12 million photographs from Getty Images collection, along with the associated captions and metadata without permission or compensation. This is all alleged, but we understand how the model works. So to understand how this happens, how this giant meets this other giant, let's talk for just a second about Getty's business model. So I created this, and none of this is from Getty. You'll see lots of stars. Getty's business model is, well, first off, Getty Images Holdings, in case you didn't know, is basically a licensing house for what's now a library of over 477 million photographs. So that's a lot of photographs. It targets all kinds of markets, and it offers licenses for these copyright photographs at different levels, depending on who you are and what you're doing with it. So a lot of companies have, for example, a blanket license for Getty. That might be something like a major newspaper or a major magazine or a major publishing house. But the way Getty works is that its photos are out there. If anyone has searched for images and has come across some that have sort of a watermark on them that says Getty Images or stock photo or something like that, that leads you to the Getty website. And from there, you can pull up the photograph, and then you can walk through steps to order and contract for use of that image. Now, I've created what a Getty image and caption might look like. So this is a photo of a sea lion. You can see Catalina Island in the background. There's a gull that's looking the same direction. This is, just so you know, one of Wikimedia Commons' most loved images. It's most often used. So I got a photo credit here. It says photo credit, rhododendries. That's what the user, the photographer calls himself. It's a California sea lion and a Western gull. And I wrote, it's reproduced under the Creative Commons Attribution Share Alike 4.0 International License. And there's an internet link that you can go and read the license. All of that is exactly what is required to reproduce a Wikimedia Commons image under that license. So anyway, the caption I wrote is, a sea lion and a gull on a rock, and La Jolla gazed nobly out to see Catalina Island in the background. So Getty image captions are like that too. So you got image and you got text. So what happens? Stability AI uses what's called the Stable Diffusion AI model. Mike sort of described how these things work. What they do, first off, these things come from the internet when you order them. So let's go back to the horror movie, right? It came from the internet. So Stable Diffusion is a deep learning text-to-image model. Stability AI allows you to generate images. And what it does is it pulls photos and text from anywhere on the internet, including Getty and other licensing house sources. There are lots of them. And then it encodes them and decodes them in the process of, it introduces noise. And then it takes the noise away. And this is just the process it uses to create. So it copies images, so it pulls them in, it's copying them in its own systems. That's copyright infringement. It doesn't matter whether it's outward facing or not, that's infringement. Then it alters them. That's also an exclusive right that a copyright owner has. It then copies it again. It creates derivative works and it sells them. So all of those things are copyright infringing, and they all add up to each instance of copying, each instance of derivation. All of those are arguably copyright infringement. So what it does then is it puts together this image, for example. So you put in a request for a cat wearing a scarf and a hat. Now you'll notice that this image I pulled from the complaint that Getty filed. So allegedly, this image is a composite. It's based on a bunch of Getty images. So Getty has figured out that this particular cat, while it is not itself a direct Getty image copy, to create it, Stability had to make multiple copies and then it merged them together in this derivative work. So that's a lot of copying to create that. And if true, if these allegations are one on any level, and I do predict that this kind of liability is going to be argued all the way up to the Supreme Court, because this is, like the Google thumbnails fight, something that is very new, and there are going to be questions about to what extent it's infringing. And I'm not even going to opine about that right now. All I can tell you is that to say that Getty is a flesh-eating enforcer is a very big understatement. So anyway, here's what Getty has asked for: a finding of willful copyright infringement, that it's a false and altered copyright management info on it. So that's a violation of federal law. There's assorted trademark and unfair competition, dilution and tarnishment claims. And the dilution and tarnishment come from using Getty images to create images that are maybe offensive or racist or biased in some other way. They've asked for a permanent injunction. They've asked for an accounting of damages, an accounting of profits, and they've asked for statutory and punitive trouble damages and attorney fees. This is to the tune of hundreds of millions of dollars. So staggering is a very good way of putting it if they actually won. And it could be you. So don't let that happen. Anyway, on to trademark, because I think I've scared everyone to death enough about copyright. So any content generated for advertising or marketing that's directed outward could theoretically use trademarks of other parties. In fact, it well might. And in some ways, the more descriptive a trademark is, that is, the more common words that make up, the more likely it's going to be out there in a way that might be infringing. So basically, if a trademark logo turns up in one of your promotional pieces online, or something that's in a blast email, which is something that regularly happens, if that image is, let's just say, you know, the Starbucks logo or something that's a famous image, that could be copyright infringement, but also trademark infringement if there's anything about it that creates confusion in the consumer mind that there's a common source association or sponsorship of these goods, that you're responsible for the services that, you know, or goods that Coca-Cola does or Starbucks does or something like that. To the extent that things that you say are not true, that is, that let's say your clever chat GPT comes up with advertising copy, and it does, people use it for that, and it makes a claim. Like, let's say it says, you know, we have 30% more magnesium in our product than other trademark, you know, It's like the toothpaste ads, right? So then you're not only facing possibly a false advertising claim if that 30% more magnesium isn't true, but to the extent that you're comparing yourself to another seller of goods and services, then that's arguably all sorts of unfair competition, and it's something that you need people to look at to avoid. So, like Chaz, I sat down and imagined some of the disasters that could happen. People use real companies to brainstorm trademarks. So, but what if you just used an AI and said, create a drug name, right? And this is just crazy, but Coke, Pepsi, Chevium, right? I mean, we listen to these ads and there are these trademarks and you just think, where did that come from? Mostly they come from real people whose job it is to think of words. So if you use the machine, you're always going to risk it combing into the mark something that isn't like Coke, Pepsi, Chevy, but is actually equally a trademark of some company. And you might not even know it until you get the cease and desist letter. Again, to the extent you're using AI to create designs to use for logos, that's potentially trademark and copyright infringing. And to the extent you use AI to create content, it's the same issue, or it's an overlapping issue with the copyright issue. Anything that you're claiming, anything that you're stating, any other trademarks can be problematic. Now let's talk about a more sort of ephemeral thing, but it's a real issue, is damaging your own brand. So all a trademark is about, and all your branding is about, is what people feel about your company and about the goods and services. So anything that you do, anything that your company does that lands you on the front page of the New York Times for something embarrassing is going to damage your brand potentially. You don't want to do that. So just to back up a second, I want to talk a little bit about what AIs are good at and not good at. Now, Mike covered all of the things you really need to know about how it works. But basically, AIs are really great, but they're also kind of nonsense artists. Imagine a sophomore English student writing a paper late at night, and you're just, I don't know, and you're just making things up about this Jane Austen book that you read, right? The AI is pretty good at generating that kind of content, but it wouldn't stand up to expert analysis. So anyway, I like to talk about the AI expert Janelle Shane, and this is kind of a side project originally of hers, and she has a wonderful blog called AI Weirdness where she works with this. But what she did was she has been for years using different AIs to put in data sets and ask those AI networks to generate something. One of the things that she asked it to generate after putting tons of language in is pickup lines. So her book that came out a few years ago is called You Look Like a Thing and I Love You. And that was one of the more straightforward pickup lines that it came up with. Most of the results are pretty weird. So anyway, so you kind of get a sense of the limits of AI. One of the things that Janelle Shane says about AI is that it's very good at sounding like a human, but you still need an actual human to evaluate content, and I'm going to repeat that in a second. So what are ways that AI has actually, I have seen it damage a brand. So KFC, like many companies, uses, I'm going to call it like a Plinko machine, but they match, or any game where a ball falls down little tubes into a set lineup. So what it did was it had push notifications on social media, and it had one column was holidays, and then the other column is promotions. So one of their big push promotions was cheesy chicken. We're going to set aside for the moment whether cheesy chicken sounds good to you. What it did, though, in Germany was it used the German calendar, does it differently in every country. So in India, it might say Diwali cheesy chicken, or Diwali, or try our new mashed potatoes. Again, whether that's a good idea, we'll set that aside. But in Germany, just this last year, in November, on November 10th, it pushed a notification inviting people to commemorate the Kristallnacht with a cheesy chicken treat. Now, you probably don't know, some of you, maybe some of you do know, that the Kristallnacht was a gigantic cross-Germany anti-Jewish pogrom where under Nazi direction, synagogues were smashed, Jewish businesses were broken into, Jewish homes were vandalized, and 100 people died. So that's not something where you want a cheesy chicken holiday push notification to go out. And there was immediate outrage. So they pulled it and apologized, and their excuse was, a robot did this. Well, that's only so good, really. You still need to have some accountability for what you do. And that's a brand damager. KFC is going to be fine, but you never know what it's going to do that truly, truly brands you as problematic. Because AI is this, there's still this kind of garbage in, garbage out thing where, to take another example, Tesla had a system where, and it's not the only company that does that, where it has a recognition point where you might run into a pedestrian. And it turned out that the technology didn't see people of color as easily as it saw white people. And it's about contrast in images, but the output is racist. So you have to have something that corrects for these things. And it's, as Chaz said, I'm not even going to go into detail on that, just as easy to create racist content by pulling stuff from all over the internet. If it makes you gasp, it will make everybody else gasp too. You need to have real humans reviewing content. And they can do things like Google Kristallnacht and cheesy chicken and see if they go together. Very quickly, name, image, likeness issues are just state laws protect people's rights to use their images in any way in a lot of cases. So if you're commercializing something and it's yanked someone's image off the net, that's potentially problematic, whether it's a public person or a private person, because the law covers both of those. If it's not some sort of fair use, and if it's in commercial stuff, it's mostly not gonna be, then it's potentially problematic. And trade secrets, it's just a base requirement of keeping your trade secrets internal and not wandering around for other people to use, is that it's kept secret. And companies are expected to take reasonable steps to protect trade secret. So if you just let it out, it's probably not going to be a sufficient excuse to a court that you just didn't know because it was a robot. Anyway, as I said before, they go together sometimes in a really horrible stew. The Getty complaint's a good example where you have a use that pulls in things from all over the place and creates this horrible mess that's trademark infringing. It includes copyright images. It involves competition, unfair competition claims, and takes maybe Ben Affleck's image and throws it in there. So that's really potentially problematic. And for that reason, even though they're expensive and they need to eat, you still need real humans for now. And there's really no replacement for that. And there won't be any excuse, I think, for not using that. Anyway, I'm going to hand it back to my colleagues to go on with this.
Terrific. Thank you, Laura. And not only need humans, we need lawyers. So now you've decided to use one of these chat tools, or maybe you're running the other direction. First stop is going to be looking at the terms of use and the content policy. And you'll see many of the elements and issues that Chaz and Laura were calling out come to play in the terms of use and content policies. Some of the terms and content policies may be good for companies that are going to be using these open AI tools. Other terms, as I'll highlight, in some sense they sound like they're protections, but when you dig deeper, those protections are likely illusory. So anyway, just some of the provisions. I just picked OpenAI because it's such a common tool for DALL-E 2 and for ChatGPT and one of the bigger players. Some of the technical terms, when you're using the tools, you can't start decompiling, reverse assembling, and web crawling and scraping. And many of the tools in OpenAI are sort of coming out now, and in a few weeks are going to be coming out with some sort of commercial versions and other pay-to-play kind of things that might make some of the usage a little more clear. You still can't infringe and misappropriate others' rights. And that, I think, is the scary thing, like Laura was saying, that even when you go through the terms of use, it's very clear that the liability remains on the company using it, on the person using the tool. And the indemnity provision is very low, not sort of commercially significant. And some surprises, if you are using these tools, you do have to have, you swear that you have the authority to bind the company that you're using it on behalf of. So that certainly could raise some issues with employees. But just in the interest of time, and thank you, we've got some questions, and please keep them coming in. We'll definitely get to them. The content policy is very interesting, and in some ways, as I said, is good for companies. It's basically in the OpenAI platform, like DALL-E 2, it is a G-rated content policy, do no harm, in that, like you see in some other platforms, where they don't want you submitting harmful content and some of the racist content, other types of content that we've talked about. One big aspect, and this was a question in the chat, was do you have to just have a disclaimer or at least like an attribution that this is AI generated? Yes, that's good practice. You don't want to be misleading that you're the author when you're not, or that you're the author of the content when you're not. And the terms and content policy of these tools often explicitly require that, and saying that you can't say it's human generated work when it's not. So, definitely indicate that it's AI generated. Perhaps one surprising thing, given sort of how we think about public figures, the content policy says do not create images of public figures, including politicians. And then the thing that I think is really illusory in some ways is when you go through the terms of use, and this can be misleading for many of your managers and your employees, is that when you read it, it says, well, we assume you know all about the ownership of the input, which in many situations you likely won't. And then it also says that OpenAI assigned you all ownership rights. So in some sense, that sounds like a really good thing. I generate a new image of a printed circuit board and a cat, or a Valentine card, and now I own the entire right, title, and interest. It sounds like I'm getting clear title. But of course, that does not, just because it's in the content policy or the terms of use, it doesn't override the actual underlying copyright issues. And in general, for just pure AI generated images, many of the, certainly in the United States and other countries, are basically saying something that's generated by AI alone doesn't have ownership. And so in some ways, OpenAI, you can argue, doesn't have title to transfer to you. There are some exceptions to that where it's AI assisted. We're seeing this at the Copyright Office. And then some of the patent aspects when you're patenting some of these tools and inventions in there. But you have to have human involvement to actually have ownership. If it's just the AI tool alone, then they don't have ownership to convey in most jurisdictions. And you're responsible for the content. And just in the interest of time, I'll go really quick. Here's some of the do's and don'ts on the content policy. No hate, harassment, self-harm, sexuality, shocking content, and then the illegal activity, no deception, and especially the political stuff, which I think is kind of a surprise, that you're not influencing campaigns, which has been an issue here in the US. And so just to sum up on some of the best practices, we think as a practical matter, you're in business, the tools are widespread, there's a lot of pressure to use them. The risks are very real. The copyright risks for sure are unsettled and real. And we're just recommending you got to have your shields up, strengthen your content creation guardrails, analyze the risks like Chaz and Laura was talking about on the HR IP side, especially the copyright side. Create policies. You may already have some existing content policies, but just be aware that these new tools are generating new content. And so they do have a different flavor and risk profile than when you're just sort of linking to a site and assessing a source than maybe your employees are used to. And stay up to date on the law because it will be moving fast. Just to close, I think what's really scary for people, we've touched on it, is that now the tools are getting so good that they're operating faster than humans, and in some ways are approximating a human response. And I typed in DALL-E 2, Isaac Asimov's 3 Laws of Robotics and CAT, and comic book style, and you get a reasonable comic book cover. And can a robot do no harm? Well, we had to ask ChatGPT. I asked if ChatGPT, if they're sentient, and of course you get an answer saying, no, I do not have thoughts. I'm not a sentient being. My humble opinion, it really looks like a lawyer helped the AI tool write this, but who knows? And then, of course, we had to ask ChatGPT if should you have lawyers review the output of ChatGPT? And the answer from ChatGPT itself was very clear that I'm just a machine learning model. I can produce errors or biased content, so please make sure you verify. So keep your protections in place and safeguard when you can. So with that, we will open it up to questions. And I'll go ahead and take a stab at a few of them, Chaz and Laura, and then you can jump in if you like. We've got a couple minutes. One person was saying, given the risk of copyright, should I just prohibit all use? My sense is that is certainly the safe approach. And it may be difficult as a practical matter. Some organizations like universities, schools may be relying on fair use and exceptions like that. Even some of that could be unsettled, but a fair use analysis is complicated. Commercial entities are in a much more difficult situation in terms of, and some of it will be depending on how they're going to use the equipment internally, the content, internal, outside. But even internal use can raise copyright risks. You want to add anything to that, Laura? Or?
No, I would say that in a way we can align into a question about how educational institutions have been handling them. Honestly, I think people are in a very reactive situation right now. Universities already had systems like Turnitin for evaluating whether, for example, student papers were plagiarizing. And I would expect that there will be tools that are adapted AI to fight AI, to figure out whether content is infringing in some way. It won't be perfect, but at least it'll be filtered. And honestly, I'm not sure what tools there are yet. I think it's all in the works.
Yep. I know some universities are evaluating how they conduct exams because of this. I think the day of open book take-home exam, which became widespread during COVID, is short-lived.
Yep. Blue books all the way.
I can take that last one. Should employers add language? Yeah, I think whether it's in a handbook or your IT policies, you should, have an analysis of what you're doing, have the rules of the road in there, right? What can and can't be done, what, particularly when it comes to confidential information, proprietary information, things like that, putting those notices out there is probably a best practice.
All right, well, we want to thank everyone for attending, and I'll turn it over to Sarah.
Thank you all for joining us today. Again, if you're looking for CLE credit, go ahead and complete that survey on your screen. And this concludes our program.